Welcome and good afternoon to everyone. My name is Manas Balsara and I am a third year law student. I am delighted to welcome you to the third edition of ZAL Dialogues. This series is an initiative of the Zoroastrian Alliance of Lawyers, founded by Advocate Jamshed Mistry and co-founded by Advocate Rashna Jihani, where we engage in conversations with members of the legal profession to explore advocacy beyond the courtroom through ethics, integrity, and services inspired by the Zoroastrian principle of good thoughts, good words, and good deeds. Today, I am joined by Advocate Firoz Bharucha, Bombay High Court, a practicing advocate, for a relaxed and reflective conversation on what it means to practice law with fairness, purpose, and strong moral values. So, to begin with, my first question is, what drew you to this profession and especially litigation? Was there any defining moment or experience that you set on this path?
Well, I come from a family of lawyers. My father's elder brother was a senior counsel himself, and ever since I was probably in primary school, I had this idea of becoming a lawyer. And see, at that stage, the understanding of what it meant to be a lawyer was very limited because we were living in a joint family, so we were in that sense living in the same house. And so my exposure to the law was limited to what the conversations that I would have with my uncle growing up, who was a very big influence in my growing up years. So I guess subconsciously, it's like wanting to follow him is what really drew me to the profession. And litigation, again, it was just following him because he was doing counsel practice. So my view of what a lawyer would do, or in that sense, a successful lawyer, was limited to someone practicing as a counsel. So it was not really a choice. It was just probably something which I did by default, wanting to emulate someone that I idolized.
So, your uncle was a driving force for you, your inspiration person.
Yes, absolutely. Absolutely.
So, moving to the next question. So, you're known for practicing with integrity and fairness in a profession where pressures can intensify, disputes can become complex. How do you ensure that these values continue to guide your decisions, especially when it comes to some challenging cases?
That's a very good question. See, as far as ethics are concerned, integrity is concerned, it is very these these traits are non-negotiable. See, I think what was ingrained in me, like probably from before I joined the profession, was that. Well, I mean, I was always interested in shortcuts. Growing up, like I would like to study only 1 or 2 days before the exam. I was very happy if I got passing marks. And I guess everyone around me knew that side of my personality. So what was ingrained in me was that to be successful in the profession, the easiest way and the shortest way to do it is to perhaps focus on your integrity, focus on your reputation. And that would possibly put me in the easiest chance or the fastest way to become kind of successful. So that kind of stuck, so it's like it is actually fueled by ambition. It is fueled by ambition, but that ambition also is to be considered as someone who's honest, someone who's considered to be a counsel who's practicing with integrity. And see, once you have that ambition and you have that drive, it is not very difficult to understand right from wrong. You see, like you said, there are lots of complexities involved in litigation. Lots of complexities, and we have a duty to be fair, and that duty also works on very various levels. Like, of course, the biggest duty, the most important duty is to be fair to the court.
Very much.
But along with that, there's a duty to be fair to your opponent. But at the end of the day, I mean, the person who expects you to be the maximum fairness from you is your own client, because he's the one who's actually paying you your fees. And there is a way of balancing it. You have to balance it out. I mean, sometimes you may not argue a very good case. That doesn't mean, fairness would not dictate that you tell the court that, oh, my case is not very good. Because that is again putting yourself above the cause.
Correct.
You have to still honestly think, read the law, see if you can find any way out, and then argue your case. I mean, you don't have very great belief, but the courts are not really expecting lawyers to say, oh, I don't have a good case, please dismiss this case, or please allow this case against me.
Right.
I mean, courts read body language. And I am in that sense quite expressive, even in court. So if a court kind of sees that I'm arguing a matter in a subdued manner, which would otherwise be uncharacteristic of me, they give me that leeway. They allow me to say my case and then pass the order without feeling the need to disrespect me. So I guess it's basically to do with a sense of right and wrong, and it works on different levels. And you have to address each level differently.
Yes, very true. I mean, as a law student, the major difference comes when you are outside the law school and actually in the courtroom.
Correct. Absolutely. I think like for me, when I started my career, it's like I was in Mulla and Mulla, with Mr. Hushang Nanavati.
Okay.
And I can tell you one thing. What I learned over there far outweighed what I learned in law school.
Very true. So moving forward, could you share an experience or a case where empathy, moral judgment, or simply choosing the right course made a meaningful difference either to the outcome or to the person involved?
Well, usually what I do is when I'm arguing cases, I keep morals out of the equation. You see, and of course, I mean, like I said, you have a very solid sense of right and wrong.
Correct.
But that should not be reflected in how you argue a case. Because what could be morally wrong could be legally right, and vice versa. So basically, when I talk of my morals or my sense of fairness or my sense of right or wrong, I think that part of my job is more reflected in the conferences, where I would try and nudge the client to do the right thing for the right reasons. But ultimate choice is always theirs, and it would not matter if I feel whether the client is right or wrong. Ultimately, when I go to court, my morals tell me that I must represent whatever cause that I have been briefed to represent in the best manner that I can represent. And if I can't do that, then I think I am doing a disservice to my profession.
Right.
So those are the morals that genuinely guide my practice. It's if I was to say how I put my sense of moral judgment above a cause that I was represented, then I think I'm really feeding my ego, because I am then kind of putting my values or my morals above the cause that I have been briefed to represent or the cause that I may be paid to represent.
Right.
But you asked me about a case, you asked me about a case where did anything matter? And I tell you, I can't think of any case in court where my morals have really triumphed over the cause. But you see, sometimes in some cases, I've been appointed as a mediator by
Okay.
the High Court.
Mm-hmm.
And there it's like I come down very heavily when it comes to my sense of right and wrong.
Hmm.
And I do it not to embarrass someone, because in mediation you get a chance to speak with people separately,
Correct.
independently. Like if there are two parties who are fighting each other, as a mediator, I get a chance to hear each of them out separately, hear what they have to say,
Hmm.
what they have to think, and with a very, I can very freely express to them what I feel about their behavior. And to give you an idea, it's like I once, it was a family, kind of a family dispute. And I
Okay.
was trying to, it was, I realized it was more to do with, the differences that were there in the past than anything that should really, affect
Hmm.
their chance to settle the matter at present. And there it's like I kind of implored the parties, that I embarrassed them into saying that, I mean, you people are three people from the same family, and there is three of you in the room and nine of us in the room.
Hmm.
So I think it is shameful that the three of you need nine of us to be in the room to be able to sort your differences out, when you people are actually family. You should be ashamed to call each other family and to call each other humans. Things like that, it sometimes, it sticks with the parties and they feel embarrassed into doing something which according to my morals may be right.
Hmm.
But I think it ends there. It ends there. I
Yes.
mean, mediation is something where I really try to impress upon the parties
Hmm.
to agree to the same morals that I may, want them to agree to. I don't do that in court. My morals are immaterial. When I'm standing up to argue a case, I don't care about my morals.
Very true. A very different and a very reality check perspective of this question, I would say.
See, because again, I'm telling you, if you have that ambition to do well, I mean, no, but like people may appreciate, like you don't just want people to appreciate your honesty or integrity, right?
Very
You
true.
need people to also appreciate your advocacy.
Yes. True.
So that is my focus when I'm standing up in court. It's not about people, what impression they have of me. I mean, it's not something which really guides the way I would argue a matter. My morals don't guide my arguments.
Yes. And then another question that looking
Yes.
at this legal profession as a whole, how do you think principled advocacy can help shape a stronger and more legal culture, ethical legal culture? And what small practical steps can young lawyers take to contribute to that change?
See, in terms of advocacy, I
Hmm.
think the strongest principle one must keep in mind is leave the facts for the clients. Let them deal with the facts. Don't suggest facts. See, we all of us lawyers have a decent understanding of the law. Like once you, I mean, when you put so many years in the profession, you get a decent understanding of the law.
Right.
So therefore, sometimes when facts are not always in black and white, you may feel the temptation, because you know what the law, how to apply the law to a given set
Yes.
of facts. That temptation is always there to put words in a client's mouth.
Hmm.
I mean, our job is not to do that. I mean, I would never encourage anyone to suggest things to the client. It is for two reasons. One is that it is absolutely wrong to do that.
Hmm.
And second is the client will never understand why we are making him say what we said. And especially if it's a trial matter or an arbitration matter where he will be cross examined. I mean, he will not even be able to withstand the cross examination. I mean, on paper, the facts may seem fine, but if something has not happened, the client will get found out.
Correct.
Having said that, there may be times when you are faced with very inconvenient facts, and principled advocacy should dictate that when you are faced with this situation, if you are putting in, say, 12 hours or 15 hours of hard work to be able to argue a matter, put in 25 hours,
Hmm.
put in 50 hours. It's all right. You will find a way. The law is so complex and it works on so many different levels that it will always give you an answer to make a respectable argument. So focus on that part. That is our job as principal. Like when you're talking of principles, it's not about sitting as lawyers or as counsels deciding what is right and wrong and then sticking to it.
Right.
Idea is to be curious,
Correct.
have that drive that no, I don't want to make a fool of myself in court. So what if this matter is difficult? I
Hmm.
will find a way. And then just do it. I mean, put in as many hours as you need to. Don't sleep if you don't have to. But hard work has to be. You have to do that. Find a way. Don't make a fool of yourself. That is the approach that I would try to explain to young lawyers.
Yes, so very true. And now with AI also
Firoz, I am Firoz.
yes.
Sirs have left India in 1947.
Yes, Firoz. So now, since AI has also come into picture, it's like we are competing with AI as well.
I don't think you are competing with AI. Nobody should be competing with AI. You see, because by its very nature, AI is artificial.
Hmm.
See, but so for I mean the whole point of AI is if you learn to use AI to your advantage, it is a very helpful tool. I
Right.
mean, many lawyers ask me if I rely on AI sometimes, and I do. I tell them yes, I do, and they're like, how are you so frank about it? I mean, because I said that as far as AI is concerned, I don't rely on AI to write an argument down for me in court.
Correct.
The reliance is that if some research, if you are, you see, when we are talking of young lawyers,
Hmm.
the best way to research is still to go to your law commentaries and
Hmm.
read the judgments. There is no substitute for that because you can, and the reason being you can afford to do that
Correct.
when you are young because you will have time on your hands.
Hmm.
So you understand, when you have time on your hands, you don't always have to rely on speed.
Right.
And when you are spending that time to to go through the commentary, to read the judgments that you find in the commentary, by and large, but as a general rule, 70% of what you read will not even be relevant to the research that you are doing. But if every time that you are doing research, you end up reading more than double of irrelevant stuff, that is what really adds to your experience.
Correct.
Because at some stage, whatever you read sticks, relevant or irrelevant. And you end up, knowing so many different things which may not be required for the research that you are focused on, but it will definitely help you in future.
Future. Yes.
And then when you are, of course, when there is a time crunch, AI always helps. I mean, AI definitely helps me. But again, it will help you from a research perspective.
Hmm.
It won't advance arguments for you and it is not going to decide matters for you.
Correct. Yes. So, the litigation can naturally become adversarial. In tense or high
Yes.
situation, how do you personally maintain the respect and compassion while still advocating firmly for your client?
Uh, so when you talk of respect and compassion, is it for the opponents? Is it for the court? Or is it for the own client? It again, it
Correct.
works on different levels, right?
Yes.
If we are talking of the opponent, of course, it's like the respect is mutual.
Hmm.
As far as the court is concerned, I mean, respect will be mutual, but once in a while, if you find that a judge is being unfair, you have to understand that even like people at my level, like
Hmm.
we've been in the profession for like little under 2 decades as a counsel. I've been functioning. Like this is my 18th year in practice.
Wow.
No, anybody becoming a high court judge would have at least maybe 25 years of practice or close to 25 years of practice. And that is when you are a new judge.
Yes.
Then you spend 5 years as a judge, 10 years as a judge,
Yes.
12 years as a judge. Now, you have to understand the busiest of councils. The busiest of councils have got 15 matters a day. That also I'm exaggerating. I'm exaggerating. But it's 15 matters a day. A judge has, on a daily basis, 50 matters a day, maybe 100.
Correct.
Like a counsel goes to court, argues a case, goes to the bar room or goes back to chambers, does some other work, then goes back to court. A judge is in court all the time.
Yes.
So you have to understand that every year that a judge spends on the bench, the gap between what they would have, what the knowledge you acquire as a counsel and they acquire as a judge is very vast.
Correct.
And therefore, you have to give them respect from that angle and understand that a judge does not have anything personal against you. Mistakes everyone makes, so you have to make allowance for that.
True.
But at the end of the day, if a judge is saying something 9 times, or I would say 99% of the times, they have good reason for saying what they want to say, but their rosters are so burdened that they don't have the luxury of time to be able to break it down to you and explain why they are doing a certain thing. And then at that instance, you have to keep your mouth shut sometimes and come back, think, and come out with an answer. Like I said, you see, the same principles apply. Like you have to go back and understand why the judge did what the judge did and then address it.
Mm.
So there is no compassion there. You see, ultimately, that is purely respect. Pure, like it has to be, because ultimately, who becomes a judge? I mean, people who are in that sense thought fit by our own system to become judges. Only those people
Right.
become judges.
Right.
So you have to give them that respect. And it is not and you have to, most important is you have to understand that when I'm talking of giving the judge respect, it is not the person that occupies the chair. It is the chair itself. So any person occupying that chair has to be respected for the same reason.
Very true.
It
Yes.
is not the person. Correct? Because there are litigants in court and ultimately we are also part of the same system. They are part of the same system. If we don't respect judges, then how will the litigants respect judges?
True.
So you have to have that in mind at all times. And of course, for your client, I mean, that compassion is there, but objectivity also has to be there.
Mm.
I mean, there will always be times when you have some disagreement with a judge or with your opponent. And when that happens, it is also important to learn to let go and not be too hard on yourself.
Yes.
You can't hold on to it. You can't hold on to something someone said, or you may make a mistake. But you will only be able to forgive others if you forgive yourself.
True.
So all these things are very important. Like you have to treat others the way you want to be treated. But more importantly, you have to also treat yourself the way you want others to treat you. Don't be too hard on yourself and then, keep thinking and overthinking and go into a downward spiral.
Very true. So, sir, the last but not the least question. If you could leave the next generation of Zoroastrian lawyers with just one guiding principle, one that brings together legal excellence, integrity, and faith-driven values, what would it be?
See, faith-driven values, I would say it's like when you're talking of good thoughts, good words, good deeds, right?
Yes.
Now, there is no substitute for them. But this is not something I would say for the next generation of lawyers or young people. I think these are universal principles. It applies across the board to everyone.
So true.
Each person. So it basically, if you have a decent upbringing, you will have a fair sense of right and wrong. And if you have a fair sense of right and wrong, please don't compromise on your principles. If you feel that doing something is right, you must do it. You don't worry about the consequences. Because if you are doing the right thing for the right reasons, there cannot be any adverse consequences. You have to have that faith. That is my definition of faith. Like when you combine your thoughts, words, and deeds, faith You have to have faith in that. You have to have faith in your judgment, and judgment not from the point of view of society, judgment from the point of view of your instinct. What does your instinct tell you? Because you see, society is such that they will always find a way to justify their actions.
Correct.
Can you find a way to justify your actions? And if the answer to that is yes, do not compromise ever.
Very, very true that. I mean, this is all something where, as you've been practicing since so many years and you've been seeing transitions also happening in courtrooms and with taking up different clients and all. So it
Yes.
gives us a better perspective to understand the whole legal field.
See, change is the only constant, no? I mean, adaptability, therefore, adaptability is very important. And
True.
while you will keep adapting to situations, your values have to be unchanged. Unchanged. Your values should never change.
Yes, very
Your
true.
principles should never change. Only the situation changes. How you deal with that situation obviously has to change, or you will get left behind.
Correct.
If I was to do the same things today as I used to do when I started practice, then I would have wasted the last 18 years of practice. I would have learned nothing. So you have to keep evolving. You have to keep changing. You have to accept change. But your values, your instinct, you have to have faith in that. I think that is for every person, whether lawyer, whether doctor, or whatever you may be doing. But you have to have faith in your values. And if you really have faith in your values, don't care about what society thinks about them.
Very true, sir. Thank you very much for your time, for the insights you delivered today. And the reflections will surely remind us that practice of law is not just about the arguments and outcomes, but also about the values we carry in this very profession every day. On behalf of the Zoroastrian Alliance of Lawyers, thank you to our listeners for joining us for this third session of ZAL Dialogues. We hope today's conversation encourages young lawyers to strive not only for legal excellence, but also to practice with good thoughts, good words, and good deeds. Until next time, thank you.
Thank you, Manas. Thank you so much. And I would say